Do you have any reason to believe that that wasn't also as a result of Andy McGovern's efforts to try and get the city to outsource ambulance billing?
I have no reason to believe it's not, or any reason at all.
Then 1 month later, Exhibit M14, there was a recommendation to the then city administrator, joint recommendation, it appears, by the finance director and the fire chief with regard to ambulance fees and billing practices, correct? And despite the evidence of the emails that we just showed you on Andy's efforts to get it outsourced, the decision was made and recommended not to outsource the ambulance billing in 2003.
That's what it happened.
The city had no other documents responsive to our subpoena requesting evidence of Andy McGovern's efforts to outsource. Is that correct?
That's what I said.
Document M18 that is in front of you. This is a document that the city produced in response to our subpoena. Are you able to explain what M18 is? Is this something that you received about outsourcing in response to the more recent efforts to outsource?
I have that one.
Just give them this one.
Oh, I
You do have it.
sorry, I didn't.
It's right on top.
Yeah, I got it. I don't know what happened to it. There it is. Sorry about that.
Do you recognize M18 to be a document that the city produced in response to the subpoena?
Yes.
And is this something that the city had most recently with regard to outsourcing of ambulance billing?
Is this from our recent discussion?
Yes.
No.
Okay. Where did the city find this document?
We must have had it in a file that we were from the previous time looking at.
Okay.
'Cause that's what I had the staff do, just trying to find the stuff that was requested.
All right. And in this pile of information was his recommendation that all but the largest providers contract out for the billing services for ambulance billing,
Right.
because he deemed it to be a very complex process needing a dedicated staff.
Right.
And the city of Clinton had a part-time, or 50% of the process of a person dedicated to ambulance billing.
Right.
And she had no training on ambulance billing.
Right.
Now, if you look at Exhibit M2, which is the Chapter 17 on employee discipline,
Okay.
on the very first page, it requires that employee discipline be lawful under 2.4. You see that?
Yes.
And by that it says the discipline and the procedure which is administered does not violate city personnel rules or administrative regulations. You see that?
Mm-hmm.
And then, if you turn to page 17-4,
Yes.
Section 7 specifically requires an investigative process, doesn't it?
Yes.
And so if, under 7.1, if there's an accusation of misconduct involving a fire department member, it is to be thoroughly investigated before formal action is taken. You agree that's what it says?
I do agree with that.
And you agree that there was no thorough investigation before formal action was taken against Mr. McGovern?
We talked about that, and Mr. Pillars and I felt at the time, and Mr. Pillars was the city attorney at the time, that it didn't require an investigation for this because we already had the fact.
And the fact was the payment of the
Yes.
settlement amount.
So,
It had nothing to do with any conduct of Mr. McGovern or not that you were going to fire him, it was the fact of the payment.
Well, the conduct was what led to the payment.
And that conduct was allowing somebody to make an allegation that was neither founded nor unfounded because nobody ever got to the bottom of it.
We got the bottom of it to the point where we ended up having to pay the settlement.
So ultimately, it comes down to the settlement.
The settlement is the big issue.
Okay. It also indicates that you're not to make judgments until a thorough investigation is concluded, but no thorough investigation occurred for the reasons you just stated. Correct?
Yep.
It also indicates for accusations or complaints of serious misconduct, an investigative report must be completed. And there was no investigative report completed either, was there?
No.
And you're supposed to, under 7.2, have a summary of the incident, answering the questions who, what, where, when, and why, and that wasn't done.
No.
You were under 7.3 to conduct interviews, including the interviewee, rank, assignment, date, time, location, those present, and what was discussed. That was not done, was it?
No.
As part of the employee discipline process under 7.4, you were supposed to have an employee history done, correct? Did you do an employee history of Mr. McGovern before firing him?
We did talk about that, yeah.
And did you create a summary of his commendations, performance ratings, and previous disciplinary actions concerning the employee?
No, not a separate summary.
And did you review the departmental personnel file on Mr. McGovern?
We did look at it.
Okay. And Mr. McGovern had an exemplary personnel file, didn't he?
His file was fine.
And one of the reasons for that employee history is to take into consideration any mitigation based upon the previous status of that employee.
Correct.
And in this situation, Mr. McGovern's previous status was exemplary.
It was fine.
That's all I have.
Mr. Sibbald?
Big question about whether there are checks and balances with regard to billing. Wasn't Andrew McGovern the check? Wasn't that his responsibility to check to make sure that those codes were correct?
From the field, yes.
And that to make sure that information was correct before it was sent to the billing department?
That's correct. That's my understanding.
And even the information that you just went over showed that the finance department processed the bill.
Right. They did the actual billing, but they didn't do any coding there. They just took what they got and sent it out.
You were questioning about the $45 difference between the ALS rate and the BLS rate.
Right.
That really wasn't the issue though, was it?
No.
Wasn't it the treble damages and the fines?
Yes.
And while you were taking heat over $4.5 million settlement, do you suppose the heat would have been any lighter for $20 million or $30 million?
It would have been a lot heavier.
This was characterized as a political termination? Is that what it was?
No, sir.
Why do you say that? Explain yourself.
We felt it was a cause, you know, consulting with me and then the city attorney at the time, Dave Pillars, and that's what we felt. It met the level of cause for termination.
And what was that cause?
The size of the settlement or with the actions that led to it.
There were no debates at the settlement on the merits of the case, you said.
Right.
It was all about settlement.
Yeah,
Hadn't you, through Mr. Walker and Mr. Wolfberg, determined that the case did have merit?
yeah, we felt, I mean, it had merit, and when talking to them about it, and, you know, taking the advice of our expert witness, yeah, it had merit.
The same things they testified about today, the
Yes.
concerns that were raised.
That's
The
correct.
difference with the two separate narrative reports.
Right.
And things like that, that caused concern that couldn't be explained.
Right.
That even Cape Ireland, Taylor Pyramid said that one shouldn't be.
Right.
And the person responsible was Mr. McGovern,
Correct.
initially responsible.
Yes.
And ultimately then, Mr. Regenweiler is the chief.
Correct.
I have nothing further.
Mr. Fry.
You heard Mr. Wolfberg say that he was not a computer expert,
Yeah.
and you heard Mr. Wolfberg say that he expected somebody would make an inquiry of a computer expert to determine if there was some computer explanation, which is what Andy suspected for the difference in the reports. Correct?
Would you rephrase that again? Sorry.
You heard Mr. Wolfberg say today that he expected that Mr. Walker or someone would make an inquiry of a computer expert to
Yes.
see if there might be some basis to believe Andy's suggestion of what might have happened.
Right.
That was never done.
No.
Was it?
But we didn't get that far into the case.
No. But yet, you were satisfied that you had to settle the case.
I was satisfied that we had enough on the information I had from our counsel, from our expert witness, that there was enough there.
You heard $30 million, and that was all you needed to hear, wasn't it?
That was part of it. Just the fact that we felt just the amount of them, that it was likely they could come in and do something. There's going over thousands of claims.
That's all I
Mr. Doak.
Thank you. Can you tell me from Exhibit 7, if you need it, I can give you another copy. Need it?
Which one's that one?
That's Mr. McGovern's job description.
Oh, okay.
City Exhibit 7, yes.
Can you tell me from Exhibit 7, if it indicates, and then if so, where, that Mr. McGovern has responsibility for making sure that building codes are appropriately put on the PCR reports?
Required EMS documentation.
That he is to provide protocols on how to do that? Right?
Complete state required EMS documentation.
What does the state EMS documentation have to do with the building codes?
Medicare and Medicaid are run through the states.
Okay, and that documentation, as you've heard from other testimony, coding is usually done outside of the PCR reports, correct? So those didn't have to be done for any particular purpose other than billing.
That's right, they need to be done for billing.
So he was being proactive in writing protocols and policies and procedures so that they would in fact have that done before it went to the building department, even though that wasn't in his job description.
Well, I think it is partially in his job description at least. I think it's required, state required EMS documentation.
In order to bill it,
Yeah.
but it's not required as part of a patient care report.
No.
Now, we'll never know, will we, if was zero liability on behalf of the city, or 4.5 million in liability, or 20 million in liability because it never went to court.
That's correct.
So it's entirely possible, is it not, that all of the coding was correct?
I suppose it's possible, it's unlikely.
And your expert did not come up with a report indicating that it was not correct, did he?
No.
And he didn't do that verbally or in writing, because he only came up with an issue with regard to the facts on 2 different copies of the reports.
Right.
And that had nothing to do whatsoever with Schultheis's complaint or the litigation.
He felt that there was something which made it plausible that there was possibly something to Schultheis's complaint. That's how it was
Because-
explained to me by him.
Because he couldn't